Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. And welcome. It's nice to be on campus this morning. We have one case that will be submitted. That case is State of Iowa versus Eric Childs. We'll now hear the arguments in the case. Mr. Abbott, you may proceed.
Thank you. If it may please the court, those in attendance here today and counsel, welcome from Northeast Iowa. Today we are here to determine or to look at what the goal of the legislature has been and the legislative intent of the legislature in passing Iowa Code Section 321J.2, subsection 1, subsection 3. I know the court has already broached this topic before in State versus Comreed in 2005. However, the basis of that decision is reliance upon old case law and a different sentiment than what there is currently today. We must look at the goal and the legislative intent of the legislature in passing this code section. The goal there was to improve and remove drivers from Iowa roadways and to criminalize those driving while under impairment to protect the public. The state does have a compelling interest in protecting the public from drivers whose ability is impaired. However, there must be a logical connection between the prohibited activity and the impaired driving.
Counsel, in Comreed, back in 2005, we essentially concluded that any means any. And since that time, the legislature hasn't taken any steps to reverse us and take a different position by amending the statute. Does that suggest the legislature thinks we got it right in Comreed?
No, I think in that instance, the legislature doesn't understand the ramifications of what any means pursuant to the decision in Comreed. The word any amount has a very broad definition that would also include non-impairing metabolites and everyday metabolites that do not cause impairment that are normally found in everyday citizens. And I don't believe the legislature understands the difference between impairing metabolites and non-impairing metabolites. When the legislature included subsection 1C, that was passed to intend to do something more than just prohibit people from operating motor vehicles with controlled substances or impairing substances in their body. It was involving science that showed that yes, there are metabolites with regards to these substances that still cause impairing behavior with regards to those people.
Do you really have to be impaired to be guilty under these two statutes? I mean, look at the alcohol statute. It says 0.08, I think that's what it is. Many people may not be impaired at 0.08. They may still be able to function. It's sort of a status crime. And can't the legislature just make it a status crime that if you have any marijuana in your blood system, whether it impairs you or not, in your body, you're guilty of the crime? I mean, you go off on this under the influence, but it's not really an under the influence statute anymore. There's other ways to prove it, to prove you're guilty of that crime just by having the chemical substance in you.
Well, the legislature has determined that to be impaired with regards to the alcohol statutes, you must reach 0.08 with regards to the blood alcohol level. There hasn't been any determination whether or not you're impaired or not impaired with regards to different metabolites. Some states set it at 0.05. I mean, different states set it at different things. And whether you're impaired or your ability to drive is affected, you're still guilty of the crime. I mean, there's some people at 0.08, you wouldn't know they had a drink. Well, that's true, Your Honor, but I do believe that there are unintended consequences to the state's per se ban with this regard. The court in Comreed relied upon the Phillips case in Arizona in making its determination that a per se ban applied across the board.
But isn't your argument better for the legislature than for us? I mean, we don't write the laws. Well, we interpret what they mean, and we've interpreted that any meant the metabolites, and we say in the alcohol cases, if you have more than the limit in the code, you're guilty, regardless if you're impaired or not. So, I mean, how are we, in our position as a court, able to rewrite the law the way you want it to be written? The Arizona law is much different than the Iowa law. It's written differently.
It is written slightly differently with regards to the its versus any.
Well, not slightly differently. The Iowa statute, uses the phrase any amount of controlled substance. The Arizona statute referred to metabolites, and one could argue, perhaps, and successfully argued in Arizona, that the term its metabolites in connection with a driving while under the influence statute meant active metabolites. Otherwise, you get an absurd result, according to the Arizona court in Montgomery. But our statute doesn't use that term. It uses the term any amount of controlled substance. And I'm wondering if you have an argument then that would suggest how we interpret any amount of controlled substance.
Well, Your Honor, there are many other kinds of drugs that are legal to be prescribed to different people that may fall under the Chapter 124, which indicate that you may be impaired with regards to driving under the Iowa statute. However, when you break down those metabolites that occur from ingestion of those drugs, sometimes are we talking about any metabolites? Are we talking about when those substances break down to the point where there's just carbon dioxide in your system? Because that can be a metabolite of marijuana. It can be a metabolite of other.
Well, so is it your argument that when I read the statute, any amount of controlled substance, the presence of a metabolite is not the presence of a controlled substance?
It depends on how far you get down the line. You could have a metabolite of a metabolite of a metabolite that may not be considered a controlled substance, but it's still going to be a metabolite of that original substance that's banned per statute.
But the problem of the statute, in part for you, I think, is the term any is used. So it's not a 0.05, 0.03, 0.02, it's any. So I find it, and please push back if you've got an argument, I find it hard to see how you're going to get around what any means. You might try and deal with controlled substance and say, well, in the alcohol context, you have the presence of alcohol in the bloodstream. You have controlled substance, alcohol, in the bloodstream. Here, we don't have marijuana in the bloodstream. We have a metabolite.
And I understand that, Your Honor, but I do believe that the court's definition right now is so broad that sanctions may apply to conduct which a state is not entitled to regulate and did not intend to regulate.
Counsel, is there a test out there currently available that can measure how much marijuana it takes to impair somebody's ability to drive?
There are a lot of companies right now that are trying to make those determinations. Right now, we do have blood tests that are available that do measure whether or not you have the hydroxy THC metabolite or the carboxy THC metabolite. The carboxy THC metabolite is the metabolite of the hydroxy THC metabolite. The carboxy THC is the non-impairing metabolite of marijuana, where the hydroxy is the impairing version of marijuana.
Is this the best test case, though, because we have evidence that your client was impaired and that he's driving over on the wrong side of the road, wasn't he?
He did drive on the wrong side of the road, Your Honor. But I mean,
and then he admits he had just smoked half a joint. So it's I think a better test case would be somebody who's using legally medical marijuana some earlier day, is absolutely not impaired, and then gets charged.
Well, and I understand that, Your Honor, but you could look at, like you said, the medical marijuana. You could look at someone who went to the Mayo Clinic in Minnesota for treatment. Minnesota has a medical marijuana statute on the books. They were legally prescribed marijuana, and then pursuant to a doctor's orders, smoked that marijuana or ingested that marijuana in some way. But then you have Nana coming home to Waterloo, and 3 weeks after she'd received her treatment, She drops her cell phone, crosses the lane, and then gets pulled over because she appears to be impaired.
But isn't there an exception for legally prescribed opiates and things in our statute? I mean, so that
Prescription drug exception.
I mean, and if marijuana is prescribed, it comes under the prescription drug exception.
But it's not prescribed in the state of Iowa,
Well,
which is part of our problem.
Let me ask this other question. Do you know what a tetrahydrocannabinols are?
Vaguely, yes. It's a version of marijuana that's used for different medical procedures and medical
It
treatments.
doesn't include the metabolites?
I'm not certain if it includes the metabolites or not, but I would assume that they would include the different metabolites, yes.
Yeah, and the code defines marijuana as being tetrahydrocannabinols. So it's defining the metabolites as being marijuana. I mean, so they said that if you have those substances in you, it's a controlled substance. And that's section 124.101, subsection 19.
The legislature in passing this statute, Your Honor, was looking at making certain that those people that were impaired were not going to be on the roads. I understand your argument with regards to the different levels of intoxication, but the legislature has determined that impairment is not until you reach .08.
Couldn't we look at it another way? The legislature didn't want anybody on the road with any intoxication, so they may have written the law overbroad and catch other people, but that's their decision, not ours.
I would agree, Your Honor, but a statute that's overbroad does not have a rational basis in passing, and it's
Well, but you don't have a due
consequences.
process argument I don't think, that I'm aware of. Was due process raised in this case? I mean, you're right, due process requires a reasonable fit between the legislature's chosen means and the purpose, but I'm not sure that's been raised.
Well, the unintended consequences, Your Honor, are that, this would in fact affect interstate travel throughout the state as well. Someone who legally purchases, consumes marijuana or recreationally or medicinally in other states could be driving across Interstate 80 from Colorado to
Let me try
Illinois.
this question. The Arizona court invoked a doctrine of statutory interpretation that we sometimes invoke, and the doctrine is absurdity, and the Arizona court at least mentioned in passing that we don't interpret statutes in a way to get absurd results. And we've invoked that doctrine from time to time as well. Make your best case to me that application of the statute in your case yields an absurd result that requires us to modify our earlier case law.
Sure. And just to be clear, I'm not suggesting that Mr. Childs did not consume marijuana. Of course, he did consume marijuana. Now, whether he did that lawfully or not is something that hasn't been determined. However, I do believe when
my problem is the statute may not be absurd as applied to your client. Might be absurd as applied to somebody else, maybe. But I'm trying to focus on this particular case.
Did the legislature intend to punish someone for something, for a non-impairing metabolite of an illegal substance? Did the legislature intend to sentence someone to a mandatory 2 days in jail for driving on Iowa roadways when they were not impaired? Did the legislature intend to fine someone a significant amount of money, the $1,250 minimum fine, suspend their license and require drug counseling because they were driving on Iowa roadways even though they were not impaired by a substance that would affect their driving?
Counsel, I want to switch gears just briefly before your first argument ends. And I noticed that your client was charged under two of the subsections. He was charged with operating under the influence of a drug, and then he was also charged under the separate subsection, which is subsection C, driving while with any amount of a controlled substance present in his person. And then I looked to the court's judgment, the judgment of conviction, and there's just a a judgment that he violated the section, 321J2. Your attack seems to be only on subsection C, the driving with some amount of the substance. But we don't even know that's what he was convicted of. How do we know he wasn't convicted of subsection A, driving under the influence of the drug? Following up on Justice Waterman's question.
And I understand the court's concern with regards to that. If you look at the appendix in the trial information, et cetera, when the police officer was doing their tests, it didn't show that he was impaired or under the influence, or his driving was such that he was impaired because of a substance in his system. So I think the intent of the court was that he was found guilty of that because he had that substance in his system, or because he tested positive for that substance. The court could also look at the transcript from the trial on the minutes as well to see the court's rationalization with regards to its order. Thank you.
Mr. Abbott, thank you as well. Mr. Bakke.
May it please the court. Good morning. My name is Thomas Bakke and I represent the state of Iowa. The defendant in this case admitted that he used and was under the influence of marijuana. Section 321J.
Did he admit he was under the influence?
Correct. The record at page 8 of the appendix says that the officer asked if he was under the influence of drugs or alcohol, and the defendant replied yes, and on follow-up he admitted that he used marijuana. Section 321J permits a conviction of OWI when a person has any amount of a controlled substance in their blood or urine.
I mean, the name of the crime is operating while intoxicated, right? So is, by any kind of normal definition of the term, is a person who has a non-impairing trace quantity of a metabolite in their system, are they intoxicated? Is that a term we would use?
Your Honor, for purposes of this statute, the per se ban permits a conviction when there is any controlled substance which includes a metabolite or derivative thereof.
Isn't the purpose of the statute to get dangerous people off the road?
Correct, Your Honor.
It's not really a status crime, is it? Or is it? I mean, the purpose of the legislature in having these enhanced penalties is to prevent, accidents in the roadway. And obviously, with drunk driving, it's a serious problem. And they've extended the statute to include, drugged driving, if you will. But isn't the purpose of the statute avoiding dangerous drivers?
That is correct, Your Honor. And however, with controlled substances such as marijuana, there's no level of which we can tell people that this amount of marijuana is going to cause you to be impaired, and below this level, you're safe to drive. So by banning any level, including any metabolite, we're telling people you cannot use a controlled substance and subsequently drive a car.
Yeah, the medical science goes in a different direction. The AMA in 1985 stated that relatively little would be gained by a per se approach to drug delivery. And then the science is compared with alcohol impairment, where the science is actually very good and very thorough. 0.08 is a reliable indicator of deprived motor skills. 0.05 is usually where it starts. Judgment gets impaired at 0.02. We've got crash studies. We've got the simulator at UCLA. We've got Grand Rapids, Michigan studies. We've got all this kind of stuff. With respect to metabolites in marijuana, to the extent there's scientific studies out there, as I understand it, number one, the non-impairing metabolite stays in the system for 30 days or more. And so we have the prospect of somebody who happened to smoke marijuana 30 days ago is arrested and charged and perhaps convicted of intoxicated driving. The active metabolite, according to studies in Norway, stays in the system for as much as 8 days. So what do we got here? I mean, there should be a reasonable fit between the statutory purpose, getting dangerous people off the road, and the statutory criteria. And I'm not sure there is a reasonable fit.
Your Honor, I would point to the fact that the legislative findings for this OWI statute note that people do not necessarily understand the consequences of using controlled substances and driving. So there is no right to use marijuana in our state. When you use that substance and you subsequently drive a car.
Not claiming, my line of argument doesn't claim that. What the line of argument I'm just working with is if this statute is designed to deal with dangerous drivers, and maybe it's more than that. I mean, maybe it is a status offense, and we've decided that if a marijuana user steps into a car, they get 2 days in jail or whatever. But if dangerous drivers is a focus to the statute, the criteria of the statute of this non-active metabolite that hangs around for 6 weeks doesn't make a whole lot of sense.
Your Honor, there's essentially two.
So maybe we should interpret the statute somewhere else.
There's essentially two purposes to this statute. By the legislature including 321J.1 sub 4, by defining controlled substances as including any metabolite or derivative, by doing so, the legislature is, one, reducing the number of impaired drivers, and two, they are creating an additional disincentive for using controlled substances and driving while that is in your system. That's the intent of this statute, is to prevent people from using controlled substances and then driving. And this is, it shows the harmonization of the statutes when you consider that a conviction of a possession of a controlled substance simultaneously comes with a mandatory driver's license revocation. The legislature doesn't want people having drugs, using them, and then driving cars. And that's where the intent of this statute comes from, and that's where the per se ban comes in.
Counsel, do you concede that the defendant was convicted under 321J2 1C?
Your Honor, I agree with your interpretation of the record that it's a little ambiguous between the two. It's our position that under either A or C that there's sufficient evidence here. However, if the court finds that there needs to be clarification, the appropriate remedy would be a remand for new conclusions of law by the trial court. But under either A or C, the per se ban or the driving under the influence, both are met by the minutes of testimony in this case. The defendant was driving with both wheels left of the center line and continued to stay there until the traffic stop was initiated. There was indication that he used marijuana and the metabolites were found in his system.
Did the defendant raise a constitutional challenge to the statute?
No, Your Honor. There was no constitutional argument made below nor on appeal. It's just merely a statutory interpretation that we're dealing with.
But following up on Justice Apple's question, shouldn't we interpret the statute to avoid any constitutional question? Does that suggest that we should take a hard look at whether it makes sense to apply it to any trace amount?
Your Honor, I disagree that that's necessary in this case because looking at the plain language of the statute, any metabolite or derivative, the plain language of that is sufficiently clear and unambiguous.
Oh, no. There's due process vagueness, but there's also due process reasonable fit. And when we look at due process for purposes of reasonable fit, the over-inclusiveness or under-inclusiveness of the statute is a criteria. Now, it is clear, I mean, the cases are rife, that we don't micromanage that with respect. I mean, it's got to be a reasonable fit. But an argument might be made that this fit isn't reasonable at all when the statute draws in people with non-active metabolites that may have had a marijuana exposure weeks earlier. I mean, it is way over-inclusive. And arguably it's under-inclusive too if the active metabolite stays in the system for 8 days. Do we really have a rationale for this per se rule, if that science is correct?
Your Honor, the problem with that is that wasn't raised in this case. There was no argument made that there was a due process violation. But beyond that, there has to be signs of impairment in order for the traffic, well, there has to be a traffic stop to begin with.
Well, your traffic stop was pretty good, I think.
Yes, and I don't think that's a question today. However, beyond that, there has to be signs of impairment before this urine test is even going to happen. Officers aren't randomly conducting urine samples on every traffic stop. There has to be reasonable belief that there was impairment before this is even
Well, you don't need impaired driving to do a traffic stop. If an officer is at in fact, I think we just had a case that I reviewed where an officer observed somebody drinking heavily at Prairie Meadows, and then waited till he got in his car and followed him out there, and he was driving, and there was no reason to think the driver was impaired, but because he was intoxicated, they stopped him. And I mean, that's reasonable. You don't have to have you don't have erratic driving to stop somebody.
Certainly, that's correct. In that situation, the officer had reasonable cause to believe that they were under the influence of drugs or alcohol. And that's still a safeguard in place under the implied consent before an officer can ask for that urine or blood sample or a breath sample for an alcohol test. But the essential problem with this case is that carboxy-THC, the inactive metabolite, can only be in your system if you use marijuana. There is no lawful or other way to get that metabolite.
Can we go back to the Arizona case? It does seem to me their statute is not very different from ours. Iowa, it's controlled substance or any metabolite. Their statute's controlled substance or its metabolite. I don't see a lot of difference there, and they read that statute as saying if it's a non-impairing metabolite, that's not good enough because you're going to trap lots of people that aren't really under the influence and make them criminals.
And I respectfully disagree, Justice Mansfield. The difference is its metabolite and any metabolite or derivative. The difference there is the Arizona court found that its metabolite only meant the first level of metabolite, the active ones.
But with marijuana, apparently the first metabolite is there for a very limited period of time, so that doesn't even make sense. I mean, Justice Timmer in the Arizona case thought the its reading was contrived herself. And, are the two statutes really very different?
I would say that they are. The any metabolite or derivative shows the legislature's intent to include all metabolites from marijuana.
Except it's in the context of an intoxication statute, which really is oriented toward dangerousness, and therefore a inactive metabolite should not be included.
It's geared towards preventing people from using controlled substances and driving. It's not that there is this specific metabolite, but it's...
Where do you get the notion that it's also a sort of an additional sanction for use? I mean, where does that come from? I mean, it's an interesting theory, but where do you get it from?
It's a combination of the use of any metabolite or derivative in combination with the legislature's intent that the legislative findings in 321J23, where they found that drivers do not realize the consequences of using controlled substances and then driving.
Well, see, I mean, another problem that I see potentially is, we also have statutes like vehicular homicide, where if you're driving a vehicle and you're in violation of 321J.2, then potentially if somebody dies in an accident, there's an even greater consequence. Doesn't that seem like maybe an overly severe consequence if the person has a non-impairing metabolite in their blood, and that's all?
And with the vehicular homicide case, there's case law saying that you have to have more in those situations. You have to have evidence of being under the influence. But for just a pure OWI conviction, you only need to have the per se level, the 0.08 or the...
Does carboxy-THC have any THC in it?
Your Honor, it's a derivative of THC.
Well, does it have any the elements of the chemical THC in it?
I'm not going to pretend that I'm a scientist and understand it completely, but it's my understanding that the body turns THC into hydroxy-THC and then subsequently turns that into carboxy-THC. So it's a derivative and it follows that progression.
But is it a form of THC? That's what I'm trying to figure out.
I believe so, but I'm not 100% clear on the science to that detail. Another problem with the defendant's interpretation of this statute is by limiting it to only active metabolites, it would limit the state's enforcement of this statute. The statute presently permits any amount of controlled substance in blood or urine. Primarily, those tests are done by urine because officers can perform the test. You don't have to go to a hospital. But in a urine test, you're really only going to find carboxy-THC, that inactive metabolite. It's not as reliable or accurate to find THC or that hydroxy-THC in urine. That's why it's essential that we be able to test for that inactive metabolite to find that people were using marijuana when they were driving. And beyond that, if it was changed by relying on blood samples, we're asking that officers then go to the hospitals, and have a phlebotomist take that sample, and it creates much more complications. It's more intrusive, and that's essentially what would happen if we change this interpretation.
You mentioned a little while ago that, in response to my question, you say that the case law requires that the person actually be under the influence, not merely above the limit, in order to be convicted of vehicular homicide. But Comreed was a vehicular homicide case, right? And wasn't it just what we said there was we agreed with the district court that Comreed operated a motor vehicle in violation of Section 321J21C, which is above the limit, and because it caused a death, he is guilty of violating the vehicular homicide statute. Isn't that a severe consequence?
I would disagree, and I apologize if I misspoke, but I disagree that it is a severe consequence. When someone uses a drug, marijuana, and they drive a car, they're putting the safety of others at risk.
No, but most probably not. If this metabolite stays within your system for 30 days and more, a lot of these people that are drawn within the scope of the statute are not dangerous at all.
And, Your Honor, I think the distinction here is there's no right to drive and there's no right to use a drug. And when we have evidence that someone did so, we have to be able to convict that to prevent people from committing OWIs. And because the statute is not ambiguous, we ask that this court affirm. Thank you.
Mr. Bakke, thank you as well. Mr. Abbott, you may present your rebuttal.
Thank you, Your Honors. I don't believe that this is an instance or a case, or this statute was originally imposed to specifically prohibit people from using illegal substances. This statute was, imposed to protect the public from those driving on Iowa roadways while under the impairment of an intoxicant. I do believe that the court is correct that there would be severe consequences in this case if someone were to test positive for the carboxy THC and also be in an accident with regards to the vehicle.
I don't want to overstate it, because I think we have some case law, State versus Adams, where I got reversed by these folks, where I think that Justice Heck wrote that there has to be some causal connection between being over the limit and the accident. But still, it does seem to me there's a potential of a severe consequence.
Well, in Comreed, too, they were talking about methamphetamine and the methamphetamine metabolites, which are impairing metabolites of methamphetamine. But we do have to look at how far down the road do those metabolites go again. And there are metabolites to alcohol as well that remain in the system for a very long period of time. But your blood level may not go above that 0.08 section.
Yeah, but the science in alcohol is pretty well established, and we can do this 0.08. The 0.08 is a reliable indicator of impairment according to the science. As I understand the science of marijuana, there is no reliable indicator of impairment.
There's no detectable level with regards to when you're going to be impaired or not impaired, but there are tests to determine whether or not there is the impairing or non-impairing metabolite available. Well, if there's a non-impairing metabolite, then you're not impaired, just by definition.
But if there's no test for determining impairment, one could argue we'll just have a flat-out ban, and that'll take care of the problem.
But that's not the intent of the legislature in drafting this statute.
Speaking of that, Mr. Abbott, what words in the statute are you asking us to interpret?
I'm asking you to interpret the any amount of metabolites and the actual definition of metabolite itself. Any amount of metabolite that would have to be an impairing metabolite versus a non-impairing metabolite.
And what's ambiguous about any amount?
It really goes to whether or not any amount is overbroad. When you're talking about any amount of a metabolite, metabolite is a very broad definition for lots of different things. It includes the impairing and non-impairing metabolites. So when you look at that one section of the phrase, any amount of metabolites, it is overbroad in its reach and not in step with the intent of the
Well,
legislature.
even if it's overbroad, is there anything ambiguous about it?
There's nothing terribly ambiguous about it, no. However,
So is the power of your argument this morning that the clear and unambiguous terms don't match up to what the purpose of the statute is supposed to serve?
yes, it is. The purpose of the statute is to keep impaired drivers off the road and to keep Iowans safe. The statute as it's written does not coincide with that legislative goal by including the non-impairing metabolites.
Well, we are to interpret statutes consistent with the goal and the purpose, but we also have to look at the clear and unambiguous meaning of the words of the statute. And so how do we get, do we have to, if we look at the clear and ambiguous terms of the statute, do we have to, and see that they don't match up to the purpose, do we have to maybe reconsider what the purpose of the statute might be?
I think you have to look at what the purpose of the statute would be, and whether or not the legislature actually intended to include both non-impairing and impairing metabolites itself. The word metabolites is such a broad definition that includes lots of different things that were unintended by the legislative intent of passing that. The legislative intent was to include metabolites that are impairing. That's why they expanded the statute to include 1C, to include metabolites that would cause impairment.
Well, could the legislature have intended to include all of that by just writing using broad language to corral in everything?
Well, I think the legislature a lot of times also is not, they are not medical doctors either, and a lot of times these are conferences in which they try to come to some sort of agreement without really not knowing what they're passing.
Okay.
I would also just briefly state that Mr. Bakke had indicated the difference between blood testing and urine testing. I do not believe that it is unreasonable to request blood testing in these instances. And the reason is a urine test, while indicative of what has been in the body, says nothing conclusive of what is presently in the bloodstream, and that they're emitting metabolites of drugs not listed that would be universally found in anyone. A person's rights and potential adverse consequences should not be a cost issue. It's not an undue burden for a police officer to request a blood test or even just get a search warrant for a blood test. That should not be the basis of whether or not that happens or not. We don't just take preliminary breath tests. We have to actually go to a data master to be able to obtain that. So I apologize for going over on my time. If there aren't any other questions, I thank the court.
Thank you as well, Mr. Abbott. The case of State versus Childs is now then submitted to the court, but before